Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast, the Federal Arbitration Act edition. I'm your host, Bridget Flaherty. This episode will discuss Henry Schein, Inc. versus Archer and White Sales, Inc., and Lamps Plus, Inc. versus Varela, both of which involve disputes relating to arbitration. On January 8, 2019, the Supreme Court decided Henry Schein versus Archer and White Sales, a case involving the wholly groundless exception to the general rule that courts must enforce contracts that delegate threshold arbitrability questions to an arbitrator. Archer and White Sales is a dental distributor that entered into a business agreement with Pelton & Crane, a dental equipment manufacturer. Henry Schein is the successor in interest to Pelton & Crane. The business relationship grew tense, and White Sales sued Henry Schein, alleging violations of federal and state antitrust law, seeking monetary and injunctive relief. The contract provided for arbitration of any dispute, except for certain actions seeking injunctive relief. Schein asked the court to refer the matter to arbitration, but Archer and White contended that the matter was not arbitrable because it sought injunctive relief. Schein argued that an arbitrator should decide that question. The district court sided with Archer and White, finding the basis for Schein's arbitration request to be wholly groundless. Schein appealed to the U.S. Court of Appeals for the Fifth Circuit, which affirmed the judgment of the district court. The Supreme Court granted certiorari, unanimously vacating the judgment of the Fifth Circuit and remanding the case. In an opinion delivered by Justice Kavanaugh, the Supreme Court rejected the wholly groundless exception to the general rule that courts must enforce arbitration contracts according to their terms. Such an exception, the court held, is inconsistent with the Federal Arbitration Act and the court's own precedent. On April 24, 2019, the Supreme Court decided Lamps Plus, Inc. versus Varela, a case considering whether an ambiguous agreement, in this case an employment contract, can provide the necessary contractual basis for concluding that the parties agreed to submit to class arbitration. In 2016, a hacking scheme revealed the tax information of about 1,300 employees of Lamps Plus. Frank Varela, one of the employees affected by this hack, brought a class action lawsuit in federal district court against the company. Lamps Plus responded by seeking to compel individual arbitration, relying on the terms of Varela's employment contract. The district court rejected Lamps Plus' request, instead authorizing arbitration on a class-wide basis and dismissing Varela's claims. The U.S. Court of Appeals for the Ninth Circuit affirmed that judgment, determining that the Supreme Court's 2010 decision in Stolt-Nielsen versus AnimalFeeds Int'l Corp. That a court may not compel class-wide arbitration when an agreement is silent on the availability of such arbitration, did not control here because Varela's employment agreement was ambiguous rather than silent regarding arbitration. The Supreme Court granted certiorari, and by a vote of 5-4, reversed the judgment of the Ninth Circuit and remanded the case. In an opinion delivered by Chief Justice Roberts, the Supreme Court held that under the Federal Arbitration Act, an ambiguous agreement cannot provide the necessary contractual basis for concluding that the parties agreed to submit to class arbitration. The Chief Justice's majority opinion was joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. Justice Thomas filed a concurring opinion. Justice Ginsburg filed a dissenting opinion, joined by Justices Breyer and Sotomayor. Both Justices Breyer and Sotomayor filed dissenting opinions. Justice Kagan filed a dissenting opinion, in which joined Justices Ginsburg and Breyer, and in which Justice Sotomayor joined as to Part 2. And now, to discuss the cases, we have Alita Cass, President of the New Jersey Civil Justice Institute.
So the long-awaited decision in Lamps Plus was announced, closing out a pair of cases involving arbitration that were argued together in October of last year. With both of these cases, Lamps Plus and Schein, the court was addressing attempts by lower courts to create exceptions to rules that had already been decided by the Supreme Court. Schein was the less contentious of the two cases. It was resolved quickly. The decision was announced in January. And at oral argument, there seemed to be significant consensus on the merits, so it was not surprising when it was decided 9-0, giving Justice Kavanaugh the opportunity to author his first opinion for the court. Schein involved the question of delegation clauses in arbitration agreements. Parties can agree prospectively to arbitrate the merits of a future dispute, but the scope of their arbitration agreement and whether it applies to a given dispute can also be challenged. And litigating the question of arbitrability can quickly consume the anticipated efficiencies of arbitration itself. Schein is a case in point. It was noted at oral argument that the parties were now 6 years down the road still litigating the question of arbitrability. So, under the 2010 Supreme Court decision in Rent-A-Center, parties can also agree to have that threshold question of arbitrability be decided by an arbitrator. But some lower courts have been creating an exception to that rule, claiming the authority to decide the question of arbitrability themselves when they conclude that an arbitration agreement applies to a given dispute is wholly groundless. The contract at issue in Schein included this sort of delegation clause in their arbitration agreement, and the parties also agreed to arbitrate all disputes arising out of the agreement, but excluded actions for injunctive relief. Because the plaintiffs were seeking both money damages and injunctive relief, they argued that the defendant's argument for arbitration was wholly groundless. And the question presented in Schein was whether this wholly groundless exception was consistent with the Federal Arbitration Act. The court answered this question with striking clarity. We must interpret the Act as written, and the Act in turn requires that we interpret the contract as written. When the parties to the contract have delegated the arbitrability question to an arbitrator, in other words, the court does not have the power to override that contract. The court emphasized that the matter is a simple matter of contract. Just as the court may not decide the merits question that has been delegated to an arbitrator, it may not decide an arbitrability question that parties have delegated to an arbitrator. The opinion also addressed the purported inefficiencies of arbitrators hearing even wholly meritless arguments of arbitrability. Instead, the court suggested creating a wholly meritless exception would inevitably spark collateral litigation over whether the delegation was or was not wholly meritless. And again, that the parties had now spent 6 years litigating the question seemed to establish that point. I also thought it was significant that the court emphasized the binding effect of prior Supreme Court decisions. Plaintiffs' arguments relied significantly on Sections 3 and 4 of the Federal Arbitration Act. Section 3 providing that a court must stay litigation upon being satisfied that the issue is referable to arbitration under the agreement, and Section 4 that in response to a motion by an aggrieved party, the court must compel arbitration in accordance with the terms of the agreement when the court is satisfied that the making of the agreement for arbitration or the failure to comply is not an issue. The court's answer to this was essentially that an argument that a court would always have authority to resolve the question and that an arbitrator may never do so, and the court flatly rejected that approach. That ship has sailed. The court wrote that it has consistently held that parties may delegate threshold arbitrability questions so long as the parties' agreement does so by clear and unmistakable evidence. What I thought was interesting about that is, as this is the first arbitration decision to be considered by Justices Gorsuch and Kavanaugh since joining the Supreme Court, this might be an indication of their willingness to follow existing Federal Arbitration Act precedent in subsequent cases. Now, the question at issue in Lamps Plus was more contentious. Chief Justice Roberts wrote for a 5-4 majority, with Justices Thomas, Alito, Gorsuch, and Kavanaugh joining, but Justice Thomas also filed a concurrence. Ginsburg, Breyer, Sotomayor, and Kagan also each filed dissenting opinions. The Supreme Court has long held that courts cannot compel arbitration on a class-wide basis when an agreement is silent on the question. The question in Lamps Plus was whether a court can order class arbitration when the agreement is ambiguous on the point. The short answer is no. The court held that absent unambiguous consent, courts may not presume that parties have agreed to class-wide arbitration because the class aspect fundamentally changes the nature of the traditional individualized arbitration envisioned by the Federal Arbitration Act. The court held that the ambiguity on the question of class arbitration is not sufficient. The court reversed the Ninth Circuit's decision that upheld class-wide arbitration premised on ambiguous contract language and in deference to state contract law principles. The court noted that arbitration resolves disputes with lower costs, greater efficiency, and speed. And the court explained that class arbitration sacrifices those principal advantages of arbitration, its informality, and makes the process slower, more costly, and more likely to generate a procedural morass than final judgment. And as a result, neither silence nor ambiguity provides a sufficient basis for concluding that parties agreed to undermine the central benefits of arbitration itself. The majority's approach to the role of state contract on the enforceability of arbitration agreements was significant. Ambiguity in contract language is often in the eye of the beholder. And I think it's notable that even among the dissenting justices, there was no consensus on whether the language at issue in Lamps Plus was, in fact, ambiguous. So that the majority simply deferred to lower courts on their finding of ambiguity in the contract as a matter of state law, and declining to engage in any analysis on the clarity of the agreement is probably useful as a general rule to retaining the advantages and the efficiency of arbitration under the Federal Arbitration Act, because the majority focused instead on how ambiguity with respect to agreements to arbitrate should be resolved under the Federal Arbitration Act. According to the Ninth Circuit's approach, when an agreement is ambiguous, the generally applicable state contract principles control. And specifically, according to the Ninth Circuit, California's neutral principle of contra preferendum, ambiguity in a contract should be construed against the drafter. Following that principle, the Ninth Circuit resolved that the perceived ambiguity should apply in favor of the plaintiff and concluded that the parties had consented to class-wide arbitration. The majority opinion at the U.S. Supreme Court rejected that approach and held that even neutral, generally applicable contract principles cannot interfere with the objectives of the FAA. Courts do not resolve ambiguities by asking who drafted the agreement, the court explained. Rather, the court has held that the FAA itself provides the rule. And according to the FAA, ambiguities must be resolved in favor of arbitration. I think this also has significant implications for state courts that have been looking for workarounds to the FAA. For example, in New Jersey, the Supreme Court has maintained that their state doctrine on arbitration, that was announced in a New Jersey State Court Supreme Court decision in Attlees, does not impermissibly disfavor arbitration. Rather, the New Jersey State Supreme Court has explained that they represent a consistent effort to apply neutral state contract principles, requiring that parties consent to all waivers of rights, clearly and unambiguously. My view has always been that Attlees fails because it's not a true rule of general applicability. Carving out the subset of contracts involving waivers of rights for special treatment does not place arbitration on a level field with all other contracts as required by the FAA. Rather, the treatment of such agreements impermissibly turns on the fact that an agreement to arbitrate is at issue. But Lamps Plus suggests a deeper infirmity with this sort of approach. By requiring that waivers of rights be expressed clearly and unambiguously, Attlees requires that ambiguity in agreements to arbitrate be resolved against arbitration. According to the Lamps Plus decision, even truly neutral state contract principles of general applicability cannot displace the default rules of the FAA in resolving ambiguous drafting. Just a few final takeaways on this. With separate dissents filed not only by Justices Ginsburg and Sotomayor, but also by Justices Breyer and Kagan, we did not see the consensus on the court that we had seen, for example, a couple of years ago in Kindred Nursing, where Justice Kagan wrote for the majority and Justice Breyer joined the decision. There was a sense in Kindred Nursing that the rule against waivers of constitutional rights was a category created for the purposes of reaching arbitration, As Justice Kagan put it, it seemed a rule designed to reach arbitration and also black swans, whereas the rule in Lamps Plus, resolving ambiguities against the drafters, is a long-standing principle of contract law. I think the other question at issue that maybe undermined the consensus that we saw at Kindred Nursing is the question of Lamps Plus is at its core a question of whether class-wide arbitration is generally consistent with the FAA. And that is a point on which there continues to be a lack of consensus on the U.S. Supreme Court, although I think we see in this decision there's still a majority upholding the principle that was announced in Concepcion.
Thank you for listening to this episode of SCOTUS Cast. SCOTUS Cast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUS Cast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.